First person up is our Chief Disciplinary Counsel, Doug Endy, who is going to give us a brief history of the Washington State Bar Association. I see him on the screen, so I presume he's ready to go. Chief Disciplinary Counsel Endy, proceed, please.
Thank you, Mr. President. Am I being heard loud and clear? Excellent. My name is Douglas Endy. I'm the Chief Disciplinary Counsel at the Washington State Bar Association. Good morning, Mr. President, officers, governors, staff, and guests. We are ahead of schedule, and I was expecting to begin this presentation at 10 a.m. The bad news is that I didn't have my 40 minutes to compose myself, write one's final notes in advance of a significant presentation, as one does. The good news is it gives us a little bit more time for me to engage in discursive detours. And when you're talking about history, there's plenty of opportunity for discursive detours. I'm going to share my screen. So I will be narrating a PowerPoint presentation this morning. Are we seeing a screen share? I see heads nodding. Good news. Yes. So I am here to talk about a history topic, and my title today is Brief History of the Washington State Bar Association. Please understand that I am not an historian by education or experience. Why then am I giving a presentation on the history of the Bar Association? I have been around for a long time, so that is one possible explanation. But I've also said on multiple occasions in public meetings that our history, the Bar Association's history, is important. It really matters if we're not going to doom ourselves to repeat our history, or if we are going to do so, at least we'll do so intentionally and with knowledge of what it was. Not being a historian and only having about a week to put this presentation together, I realized the title of the presentation was perhaps a little bit inaccurate. Brief is pretty accurate, but it probably should be called a brief and incomplete history of the Washington State Bar Association, because those of you who, like me, who an interested observer with curiosity about history, once you start plunging into historical data, information, and archives, you pretty quickly realize there's almost no bottom to that endeavor. There's so much interesting information. And I could have spent weeks or months, time that I did not have to devote, but I would have liked to, on this specific topic. And the other thing to understand is this is not a comprehensive history of the Bar Association. So perhaps a more accurate title would be A Brief History of the Structure of the Washington State Bar Association. I'm not going to talk much about the people. I'm going to skip over a lot of interesting and important events because they don't really bear on the development of the structure that is our topic for this series of meetings. Finally, as I said, not being a historian, but being curious about history, my favorite history and my favorite historian is Lytton Strachey, who wrote in 1918 a book known as Eminent Victorians. Yes, it was a historical biography. And if you haven't read Lytton Strachey or Eminent Victorians, I commend it to you. It is said that its fame rests on the irreverence and wit that Strachey brought to bear on his subject. So that may give you a sense of the direction I'm about to head in as I present the history of the bar. We begin by looking down from a very lofty perspective at the United States. And I want to talk just a bit to lay a foundation as between a mandatory or unified or integrated bar, which the Washington State Bar Association is, and the other way that state jurisdictions have developed to regulate the profession and the practice of law, which we'll call, for today's purposes, an agency model. The unified state bar model is depicted in orange, and the agency model depicted in green. And as you can tell, the mandatory unified model really swept the nation, particularly in the West. And we'll see some of the ways and when that trend developed in the 1920s and 1930s. But in its simplest form, the agency model means that the profession is regulated by the highest court of the state Supreme Court in most jurisdictions. And they do so directly. And any individuals who are participating in the regulation of the profession are doing so under the direct authority of the state Supreme Court. There may also be a state bar association. And let's just look at Colorado by way of example, the furthest of the Western states who use the agency model. If you decided you wanted to become admitted to practice in Colorado, if you were going thereafter engaged in the discipline system in Colorado, you would not be calling or interacting with or engaging with the Colorado Bar Association, the State Bar Association, at all. It's purely a voluntary bar association, like many of our local and specialty bar associations. You would those functions, admissions, licensing, discipline, they are all overseen by an agency of the Supreme Court, and literally in the same building as the Colorado Supreme Court. You would go to the same building to deal with those folks. So that's what we mean by an agency model: regulation under the court through an entity that assists the court in administering regulatory systems. And there very well may be a state bar association, but it is a voluntary entity, and lawyers can join that entity or not join that entity, depending on whether they think they will be getting value out of it and making contributions to it. The mandatory unified integrated model, by contrast, merges those two functions. And you will see as we go through the history of the Washington State Bar Association, very literally there's a merger of what pre-existed our current model, which was a voluntary Washington State Bar Association, and a regulatory entity that worked with the court on regulatory matters such as licensing, admissions, and discipline. So that's what we mean by unified or integrated. The professional association functions and the regulatory functions are joined, unified, integrated. And the other piece of it is that most of these bar associations are mandatory, and that's an important component of this concept, i.e., if you are going to practice law in that jurisdiction, it is required that you, as a lawyer, are a member of the State Bar Association. That's the substance of the distinction between the two models. Once upon a time, Washington was a territory of the United States. And there was a territorial legislature and a territorial Supreme Court in Olympia. And they met and convened in the then Territorial Capitol, later to become the state capitol. And it is depicted on your screen. This photo is a little bit later. This is not territorial days. I think this was in 1909, so it's looking a little unused and dilapidated. But this is the territorial and later state capitol before the grand structures that we now know of. It's the legislative building and the Supreme Court, the Temple of Justice, were built. And the Supreme Court, the territorial Supreme Court, and for a while, the Supreme Court met. The Supreme Court met in rooms of the old state capitol building. So all of that was going on in this building. In 1888, the Washington Bar Association was established. A group of like-minded lawyers who were in Olympia attending a session of the Territorial Supreme Court decided to get together and write up some articles of creation and throw a couple of bucks on the table and create a voluntary bar association. And they did, called it the Washington Bar Association. Depicted on your screen is not the day of the formation of the Washington Bar Association, because I couldn't find a photo of that event, although I would not be surprised if one exists deep in the archives of the University of Washington Law School Library or somewhere. This is formation of the Washington State Teachers Association, which I like to think it looked a lot like the day of the formation of the Washington Bar Association in 1888, although probably with a lot fewer women. Indeed, we know that the first woman who became a member of the Washington State Bar Association wasn't until 1914 or thereabouts. In 1890, the Voluntary Bar Association was renamed the Washington State Bar Association. Why? Because of statehood. And again, this is not a depiction of the festivities surrounding the renaming of the Washington State Bar Association. It is a photo of the inauguration of our first state governor, Elisha Ferry, in 1889. This is just a fragment of the first set of rules for examination and admission of attorneys adopted and enacted by the Washington State Supreme Court. And I focus on this for two reasons. One, as an initial instance of something we're going to see a lot of over the years, which is the Supreme Court enacting regulatory rules for governance of the practice of law in Washington and regulation of the profession. And this is an early instance of that. But secondarily, as a reminder of how the profession was regulated in this era, in this very early era. Bear in mind that at this time, Washington State Bar Association is a voluntary bar association. They don't have any regulatory functions. They have nothing to do with it. The profession is essentially regulated directly by the courts themselves. And if one wants to become admitted to practice law, could go before the bar of the court in a county where one wants to practice and be examined and perhaps admitted by the judge or judges of that court. Or if one wants admission statewide, one would go to the state Supreme Court in Olympia and be examined by the judges of that court. And as you can see in this rule, this was the 1891 rule that constituted disciplinary procedure in that era. there was literally one rule, and it was this. It didn't really say much about the process that the courts would use to evaluate the facts and impose discipline. But it does reflect the fact that the Supreme Court or any superior court had that authority to make decisions about whether a lawyer admitted to practice in that court or in the state as a whole would be disciplined. And these are the early days. Remember that both the territorial legislature and the first state legislature did enact some statutes defining who was eligible or authorized to practice law in the state of Washington. But at this time, it is always understood that the state Supreme Court, and to some extent the superior courts in that day, had authority to make the regulatory decisions, the admissions decisions, the disciplinary decisions to remove a lawyer from the roles of attorneys admitted to practice. So while the legislature sort of launches the foundation for who is authorized to practice, these functions are actually performed, and everybody acknowledges this through Supreme Court regulatory authority and rulemaking. This, in a sense, is a little bit of an historical detour or an interesting fact that most people don't remember or realize anymore. As you know, the ethics of the profession are governed by rules of professional conduct in every U.S. jurisdiction that have their source in the ABA model rules of professional conduct. Although they may be locally varied by state. The first such code of ethics is enacted in 1908 by the American Bar Association. They were called the Canons of Professional Ethics, and I don't think anyone practicing law anymore practiced under those canons. But they were adopted, interestingly, at the 1908 annual meeting of the American Bar Association, which took place in Seattle. I think they called it the annual convention at that time. So certainly those canons of ethics are on the minds of the Washington lawyers and the Washington State Bar. We move forward to 1909. And an entity is created called the Board of Law Examiners. As you know, we have a Board of Bar Examiners that's still exists and still works on administration of the bar exam. And the source of that in ancient history is the 1909 creation of a Board of Law Examiners. It was a legislative entity. And it was authorized essentially to assist the Supreme Court in administration of the examination of applicants for admission to the bar. And as you can see, and you don't need to read all of this, it authorized the court to appoint a board consisting of 3 lawyers, and they were paid $10 a day for each day actually spent in performance of duties and 5 cents per mile. So this is the first instance in Washington state of an entity with express authority and purpose of assisting in the administration of a regulatory function controlled by the Supreme Court, the Board of Law Examiners. Fast forward to 1917. There's a new act that substantially revises that 1909 legislation that authorized a board of bar. It was called the Board of Law Examiners at that time. And it's still composed of 3 members that need to be well qualified and so on and so forth. But note that they are tasked not only with assisting the court in examinations of applicants for admission, but also for the enforcement of the law and the ethics relating to attorneys and counsels at law in this state. So their authority is expanded beyond assisting in admissions. Now they also have some disciplinary authority as well. And just to reinforce that notion, a section of the 1917 legislation makes it quite clear that this board is going to enforce the laws of ethics. Complaints of immoral or unprofessional conduct or otherwise will be presented to the Board of Bar Examiners, and there's a little bit of procedure established around how those complaints are going to be handled and adjudicated. So the Board of Bar Examiners, a legislatively created entity, is authorized and paid to assist the Supreme Court in generally its regulatory functions over the profession. And now, and this is also part of that 1917 Act, again, an interesting historical footnote, that 1908, those 1908 canons of professional ethics adopted by the ABA at their annual convention in Seattle are now the law of the land, because part of this legislation is an express adoption of the 1908 canons, which shall be deemed the standard of ethics for guidance of members of the bar of this state. Because obviously, if this board is going to be administering a disciplinary system, that there has to be something against which to measure the conduct of the lawyers, and it's going to be the ABA canons of ethics. That is still on the books in the State Bar Act, by the way, not in exactly that language, but it's still there. All right, now we are going to digress away from Washington, if only for a moment, to take note of the fact that in 1921, the State Bar Association of North Dakota becomes the first legislatively created unified bar. And we've already established what a unified bar is. It's a merger of the Professional Association, the Voluntary Bar Association of North Dakota, with the regulatory functions administered under the control and authority of the Supreme Court. And not only does North Dakota go that way, but 9 more states follow suit between 1921 and 1932. So this obviously is trending. The dominoes, if you will, are starting to fall in the West, at least, in favor of this idea of unification of bar associations. And it didn't just come out of nowhere. The American Bar Association, the ABA, is very supportive of states who are recommending to their legislatures that by a legislative act, they unify the Bar Association. So the Bar Association will be delivering, administering on behalf of the Supreme Court the regulatory functions. And it's mandatory. That's the key, right? For every member, in order to practice, to be a member of that type of bar association. All right, this slide is a little busy, and I'm sorry about that, and we're not going to go through it all. But by 1932 into 1933, that trend, that wind that was blowing across the Western states reaches Washington state. These are excerpts from a pamphlet that was created by the Washington State Bar Association as to promote the idea of a unified bar association model in Washington state. And you can see on the left, a committee was formed by the Washington State Bar Association, a voluntary bar association, with members from all over the state to evaluate and ultimately recommend integration of the bar. It's supported by the Supreme Court justices themselves, and there were a couple of statements of support included in this pamphlet from Justice Beals and Justice Holcomb, who think that this is a splendid idea, and a former president of the Idaho State Bar weighs in this pamphlet because Idaho's already gone in that direction. The president of the ABA, I believe, and even the great Roscoe Pound was quoted in this pamphlet as saying, "This is really a terrific idea." And just you see the overview, the opening lines of this pamphlet proposing formation of an integrated Washington State Bar. By united effort, through this act, we will wield tremendous constructive influence for progress. But the really interesting piece I pulled out is just below there. The point that our legislature in 1931 appropriated $8,350 from the general fund, from which was paid the cost of admission and disbarment, i.e. discipline of lawyers. But if we go in this direction of unification of the bar, we'll pay our own expenses. That all of that expense will come off the backs of the taxpayers out of the general fund, and we'll pay for it all. Don't worry about it. And spoiler alert, the legislature thought that was a great idea. And so 1933, the legislature adopts the state, what we know as, even today, as the State Bar Act, to create an association to be known as the Washington State Bar Association, providing for its variation government membership powers to regulate the practice of law, and so on and so forth. And here's the heart of the matter. Only active members may practice law, because remember, now the Washington State Bar Association is paying for these regulatory functions, and the quid pro quo, if you will, or the sacred covenant, as I like to say, is we will fund these regulatory functions, and we will be able to do so if you give us authority to require every lawyer to be a member of the association and assess fees in order to deliver these regulatory functions. Membership becomes mandatory. And just by way of illustration, this is the section of the State Bar Act that makes it explicit that those regulatory functions are going to be assigned to the Washington State Bar Association, subject, of course, to the approval of the Supreme Court. And again, the State Bar Act is still on the books in the RCW, not in precisely the form it was enacted in 1933, but pretty close. And ta-da, we have the Washington State Bar Association integrated mandatory bar that we know today, doing its business out of the Dexter Horton building through 1947. President Charles Paul, its first then called Executive Secretary Alfred Schweppe. That is not the 1933 Alfred Schweppe, that is the 1955 Alfred Schweppe. That's his photograph on the wall of presidents at the Washington State Bar Association. So he was probably a somewhat younger man, and would have looked younger if I could have found a 1933 photo, which I did not have time to do. 1936, this is truly a discursive digression. It's when you're doing a history, sometimes you stumble upon something that's just darn interesting, and I couldn't help myself. But in 1936, the Washington Law Review merged with the Washington Bar Journal, what we now know as Washington State Bar News. And that relationship continued for quite some time through 1961. So as you can see on the right, there was this publication that was the Washington Law Review and the State Bar Journal together. And the reason for that was there just wasn't money. The Washington Law Review, the law school didn't have money to publish the Washington Law Review. So the Washington State Bar Association swooped in to help them out and publish articles out of the Law Review as part of the Bar Journal, essentially. 1947, the bar leaves the historic Dexter Horton building, and moves into the historic Morrison Hotel building, 501 3rd Avenue, which is still there. I don't have much to say about that. These are just interesting factoids about where the bar lived over the years. Although if you've attended a meeting of the Long Range Strategic Planning Council lately, you know that the issue of where the Bar Association lives is an important one, a big one, including right now. It's a topic of this session. That was originally the Arctic Club building, built in 1908. And I know it seems like decades are passing, and all I'm doing is showing you photos of where the Bar Association was housed. But by and large, I mean, a lot of interesting things were happening, but not structurally in terms of what the Bar Association is and was. They moved to the College Club building, 1966 to 1986, 505 Madison. Some of you will remember the old College Club building. It is no longer there. It was demolished to make room for another more contemporary structure. 1976, so the separation of powers litigation. Now, you'll see in the slide, I gave 1976 is plus or minus. I'm not saying that in 1976, all of a sudden it dawned on everyone that there was a separation of powers issue when it came to the regulation of the practice of law. This was a long-running evolutionary concept, but that really came to a head, or there were some cases that were very pointed on the limits of the power of the legislature to regulate the practice of law that cropped up in the late 70s and early 1980s. But this is ongoing from decades before through the present day. What is the legislative, and partly because we're created by legislation, by the State Bar Act, but what is the limits of legislative authority when it comes to regulating the practice of law in the profession? Well, in two cases, Graham against Washington State Bar Association and Castler Escrow, a pretty bright line was drawn. The Graham case, as you may know, was a case where the state auditor decided it was time to audit the books, records, and finances of the Washington State Bar Association. And the bar said, no, we don't think that's part of your authority here. And it was litigated and got to the Supreme Court, and the Supreme Court agreed. Separation of powers precludes legislative authority to audit funds collected by the bar. That's a Supreme Court function. And then Castler Escrow, that was litigation around something called the Escrow Agent Registration Act, where the legislature authorized a licensing scheme for escrow agents so that they would be governmentally authorized to select, prepare, and complete documents and instruments that affect legal rights in real estate transactions to help people engage in and close real estate transactions. And there was a lawsuit around that. And again, the Supreme Court holds that it's, again, the legislature, this is direct regulation of the practice of law, because doing that stuff is the practice of law, and only the Supreme Court has authority to regulate it. And guess what happened? The legislature couldn't authorize escrow agents to engage in the practice of law, but the court could certainly do it itself, and it did. In 1983, the court enacts the first LPO, limited practice officer rules, to admit individuals to the limited practice of law for the purpose of selecting, preparing, and completing approved documents for use in closing loans and real estate transactions. And so there was a carve out, a piece of what is considered the practice of law, this closure of real estate transactions, and another type of practitioner is authorized to do so. They're called limited practice officers, and there are plenty of limited practice officers around and engaging in this species of limited law practice as we speak today. In 1986, the Bar Association moved its offices to the beautiful Weston building on 6th Avenue. We are now probably getting into an era where some people remember when the Bar Association was in these particular buildings. And even I, who was admitted to practice in 1987, remember when the bar was in the Weston building, because I became a member of the Board of Bar Examiners before I ever was employed by the Washington State Bar Association. And the first Board of Bar Examiners meeting I ever attended was in the Weston building, so I do have a dim memory of that. 1987. The Supreme Court adopts General Rule 12, and we're all familiar with General Rule 12. We talk about General Rule 12 all the time. And remember, the Supreme Court engages in its authorized activity of regulating the practice of law largely through rulemaking. And so in 1987, the court sets forth the purposes of the Washington State Bar Association. Its general purposes, and it also sets out specific activities that are authorized and prohibited. And if you open your Washington Court Rules book today, you will find, in not an identical form, but in largely similar form, purposes of the Washington State Bar Association, specific activity authorized and prohibited. Now, you may ask yourself, why in 1987, after the 50 years, more than 50 years of operating under the State Bar Act, does the Supreme Court decide to enact a rule clearing all of this up, explaining what the purposes of the Bar Association is and what they can do and what they can't do? Why 1987? Let me tell you, or let me speculate on why that might have happened in 1987. You may recognize the name of this case, Keller against State Bar of California, and I believe it will come up again later today when General Counsel Shanklin talks about some of the First Amendment litigation, which is not my topic, but I do need to take a glancing blow at this. In 1986, a California Court of Appeals, and this case came up out of the California court system, held that the First Amendment principles actually prohibit the State Bar from requiring its members, as a condition of practicing law, from contributing to support political or ideological causes that they oppose and which are not germane to the purposes of the State Bar Act. Now, I can tell you, or at least I can speculate or imagine, that when that case came down, and remember, this is ultimately superseded, reversed on appeal, and got all the way up to the United States Supreme Court. But when that Court of Appeals decision came down and said, Bar Association can't require members to contribute money to support political or ideological causes, that news spread like wildfire among integrated mandatory bars around the country, and they started, and Supreme Courts, and they started to think, we better get our arms around this and figure out what our Bar Association is authorized to do and not do. So that's why we find a laundry list of activities authorized and activities prohibited, I believe, coming out in 1987, which seems kind of late in the game. In 1996, the Bar Association moves to the 4th and Blanchard building, and now we are certainly getting into an era where many of us remember the Bar Association living in these homes, and that was the first office where I worked as a fledgling disciplinary counsel with the Office of Disciplinary Counsel. 2001. The Supreme Court adopts General Rule 24, defining the practice of law. And again, why 2001? Why in 2001 is it suddenly important to know what the practice of law is? Given that we have decades and hundreds of years of history of lawyers practicing law. Well, the court also created an entity at that time known as the Practice of Law Board with various responsibilities. including educating the public about how to receive competent legal assistance, recommending to the Supreme Court new avenues for persons not currently authorized to practice law, and to provide legal services that might otherwise constitute the practice of law. Think LPO, already done in 1983. And to receive complaints alleging the unauthorized practice of law in Washington by any person or entity. Now, if you're going to authorize others to engage in activities that might constitute the practice of law or receive complaints about the unauthorized practice of law, it might be a good idea to know what the definition of the practice of law is. And so we've had that since 2001. And that's just a minor excerpt. It's a much longer rule, of course. 2006, the Washington State Bar Association moves to become housed in the Puget Sound Plaza, which is our current home and where many of you are sitting as we speak. 2007, GR12 is amended to deal with this notion of Supreme Court created boards and committees. It has long been the case that there were boards and committees created and reporting to the Supreme Court itself that were nevertheless housed with and administered through the Washington State Bar Association. So there's a somewhat arguably dissonant relationship between being authorized by the court and reporting to the court, and at the same time being funded and administered through the Washington State Bar Association. And as a result of some issues that were cropping up in that era around what that relationship is and should be, GR12 was amended, expanded to start to try to define the lanes for how that relationship was to work. And that's a conversation that continues to this day through the currently chartered taxi cab committee. 2009, the Board of Governors votes 7-6 not to recommend separating the lawyer discipline system from the Washington State Bar Association. This is a moment in history that is probably lost to the memory of most, but is very vivid in my memory because I was at the table for that debate, that discussion, and that vote. It occurred in the wake of some recommendations that the ABA had made after a review of Washington's discipline system, and that was being looked at by the Supreme Court and the Washington State Bar Association. And the ABA has long held the policy position that discipline systems should be administered through a direct relationship through the court and not as part of a state bar association. But that had never taken hold in Washington because Washington has always been very committed to the integrated bar model, including administration of the discipline system. And yet, taking into account the ABA's position, a number of governors pitched the idea that maybe that actually is a good idea. Maybe we should separate out the discipline system and, in a sense, give it back to the Supreme Court. It was debated at length, and there was ultimately a motion to continue the integrated bar structure with the inclusion of the discipline system, and it came down to a tie vote. This is 2009. It's not that long ago. A 6-6 vote. So it was a razor thin margin. A vote broken by acting President Stan Bastian, and he was the immediate past president at that time, but both the president and the president-elect had passed the gavel because they wanted to comment on these issues. And so an acting president turned the tide, and I'll just note that it was Governor Jeff Gibbs, then Governor Jeff Gibbs, who moved to continue the integrated structure. I believe I saw former Governor Gibbs present at today's meeting, and he probably didn't realize he had become an historical figure. So thank you for joining us, Mr. Gibbs. It reminds me a little bit of a story I once heard. Are you all familiar with the Simon and Garfunkel song, Mrs. Robinson? So, hum it to yourself. Think about it in your head. One of the lines is, where did you go, Joe DiMaggio? And the story is told that one day Paul Simon met Joe DiMaggio at a party. And Joe DiMaggio went up to him and then confronted him and said, what do you mean, where did you go, Joe DiMaggio? I'm here. I'm right here. I didn't go anywhere. And Paul Simon's comment in that interview that I heard was he wasn't capable at that moment of realizing that he had become a metaphor. So congratulations, Jeff, on becoming a historical figure and a metaphor. 2012, the limited license legal technician rule is adopted, and this is at I do not need to rehash the history of the limited license legal technician program, but it is a point in time of a moment of structural change for the Washington State Bar Association. It was a recommendation of the Practice of Law Board, and ultimately the limited license legal technician rule and the board was created. And as we all know, the program was sunsetted in 2020. 2013, GR12 is amended pertaining to review of the setting of the annual license fee, and I've highlighted the significant amendment in that portion of GR12, authorized activities. The amount of any license fee is subject to review by the Supreme Court for reasonableness and may be modified by the court if the court determines that it is not reasonable. So again, this is important structural change relating to the relationship between the Supreme Court and the Washington State Bar Association. Another little detour outside of the borders of Washington State, 2013, the Nebraska State Bar Association is ordered to semi-deunify. And that was through a petition to change the regulatory rules by a member, submitted by a member in Nebraska. And the Supreme Court did engage in some analysis and fact-finding and issued an opinion on this that rejected the idea of just complete deunification of the Nebraska State Bar, but essentially quasi-deunified through how the mandatory bar dues were managed. They authorized or required a mandatory membership assessment, and those funds could only go for regulation of the legal profession. And then the other association functions would be financed by a voluntary dues payment for non-regulatory activities that may benefit the profession as a whole. So that's Nebraska in 2013. California does something similar through some legislative change in 2017. They create a separate entity, a voluntary association called the California Lawyers Association, with the main functions of the State Bar of California remaining regulatory. This is all a little bit more complicated than I had time to depict on a slide or will go into at this point. But two things to leave you with here. One is question 2013, 2017, remember the dominoes falling in the direction of integration of bars back in the 1920s and 1930s. Did the dominoes start tipping in the other direction in the 2010s? That's a question that's still playing out. And why 2013 did the dominoes start wobbling? Well, that's a question, that's an issue around a lot of the First Amendment litigation that General Counsel will talk about later in the day. oops, a little lag, sorry about that, 2014. Access to WSBA records, GR12.4, and then note that GR12 has grown substantially since 1987 when it just described the purposes of the Bar Association, activities authorized, activities prohibited. All kinds of bells and whistles are being added to GR12 over the years. And one of the bells was the 2014 edition of provisions relating to access to public bar records. Now you might ask yourself, well, why wouldn't these records just be governed by the legislature's Public Records Act? Well, we know the answer to that question. There was some litigation in this era about access to court administrative records, and the court once again held the line, the separation of powers line, that the Public Records Act does not apply to judicial administrative records. And then the question arose, well, what about Bar Association records, given that in some senses, the bar is a creature of the Supreme Court. So the solution in 2014 was to create a separate standalone rule, court rule for access to bar records. And it was put in GR 12.4. 2014 to 2015, now we're getting into an era that is probably fresh in the minds of many of those at the table today, the BOG Governance Task Force and Work Group. And remember, this is one of those projects that started as a work group to define what the task would be. Then the board created a task force to do the task and make a recommendation. And then the BOG created another work group to look at the recommendation that the task force had made. So there's a three-step process. And it was a fairly broad charter to undertake a review of how the WSBA is operated in light of the fact that the times and circumstances surrounding operation of the organization have changed dramatically since 1933. So there was a fairly broad review of how the WSBA is governed. And the task force recommended many things, which I'm not going to delve into all of them, but what I thought was of primary interest from a structural history is the recommendation that that most provisions of the State Bar Act, which is still on the books, be repealed. And with that portion that creates the WSBA as an agency within the judicial branch under the Supreme Court's control being the only piece that was still necessary, because by and large, so much of the rest of it had been superseded by court rule or could be authorized by court rule. The task force report does acknowledge that that's probably not an urgent or pressing idea for implementation. And ultimately, the Board of Governors work group that considered the various recommendations and whether to implement them or not to implement them concluded that it was unnecessary to deal with the State Bar Act issue at this time. And there were some recommendations out of that task force process that were implemented. Just by way of example, the creation of an executive committee, which, as the board knows, is an up and running and functioning entity of the board, and others that were not implemented, such as changing the name of the Washington State Bar Association to the State Bar of Washington. 2017, GR12 is amended again, yet again. There's a lot of this GR12 amendment going on in this era. And there were a lot of things that changed somewhat in 2017, and I'm not touching on all of them here today. But of interest and significance is the introductory language, which hadn't been there before, depicted on the slide, stating that the Washington Supreme Court has an inherent and plenary authority to regulate the practice of law in Washington. Is this news in 2017? No, probably not. I mean, we've been talking about this concept since 1891. So why in 2017 has the time come to make this statement overt in a court rule? Part of it was some of the litigation, and that's been going on, the First Amendment litigation, but perhaps more so some of the antitrust litigation relating to immunity of quasi-state entities, and the importance of the governmental, the actual governmental regulator being in charge of those processes and actively supervising the persons and entities acting under the governmental entity's authority. So that was made explicit, even though it wasn't a change of law, it was just a statement of our existing structure. The court also adopted the ABA model regulatory objectives verbatim, which are now in GR12 as Rule 12.1. And those are a statement of the policy purposes that the Supreme Court has established as the what we should look to when we are regulating the profession. What are our policy objectives in enacting rules and engaging in the regulatory work? And the objectives are such things as protection of the public. Again, not new information. 2019, the Supreme Court Bar Structure Work Group. Now we are certainly in an era that nearly everyone remembers, so I don't need to talk too much about this. It was convened by the Supreme Court. It was chaired by the late, great Chief Justice Mary Fairhurst. And its purpose was to look at and make recommendations regarding the structure of the Washington State Bar in light of recent constitutional and antitrust cases. And you have all heard the story, and some of you were there on the task force. It took place over the course of many months in 2019. A report and a minority report was filed. And I have not included all of the various recommendations of that task force. Just cut to the chase by saying that a majority voted in support of retaining an integrated bar structure and not making any major changes to the structure of the bar. Which leads us to 2022. The Board of Governors group that's going to be examining the historical organization and structure of the Washington State Bar Association, ETHOS. That's you, that's us, that's now. And that brings me to the end of a brief history of the structure of the Washington State Bar Association. Good luck to you.
Okay, we have hands up. So are you ready to answer questions, Chief Disciplinary Counsel?
I'm ready if there are questions.
Okay, I think past President Scichetti has a question.
No, I just applauded that great presentation. That was
Oh, that's what it was. Okay,
Chief, and a wonderful presentation. Thank you.
I second that. Anybody else have any questions or comments about this wonderful historical overview of our Bar Association? No?
Probably for the best, because as I said, while it seems like I know a lot and there's a lot of information there, it's all very superficial. If we try to dive deep, I may have to go back to the archives.
Okay, well, we are way ahead of schedule, and what I thought we should do is, before we go into the next presentation from our General Counsel, Julie Shanklin, we ought to take a break. So I'm going to recommend, if everybody is okay with this, we take a break until about 10:35. Everybody good with that? Not seeing any objections. I'll see y'all back here ready to go at 10:35.